good morning.
Good morning.
So I got your motion relative to child support. Um, and the motion claims that his child turned 18 and graduated from high school. So I contacted them, the front of the court anyway, so they could confirm that because generally that's all you need. All you need to do is send a copy of could be a diploma, could be the high school transcripts. Once they get proof of that, they'll stop the child support. Okay. The problem is um, uh, they can't, apparently, Mr. Brown does not have access to that information. So let me first turn to Mr. Brown and then I'll hear from Miss Dennis. Is that correct, Mr. Brown? You can't figure out if this child did in fact graduate?
I hold on. What I just pushed this start video.
Right away, you can see the struggle. Mr. Brown can't even confirm the basics about his daughter's graduation without leaning on Facebook posts and a handful of photos. But here's the problem. In child support cases, courts don't accept social media as proof. They want certified records, not screenshots. This moment points to a bigger truth. When a parent is absent from their child's life, it creates gaps that go beyond emotional. They spill into the legal arena too. The judge shows patience, but also makes the message clear. If you're asking for legal relief, you need legal evidence to back it up. So, here's the question. Should the father have been more proactive in staying connected to his daughter's milestones? Or is this a case where life circumstances got in the way?
Go ahead.
I can't get the camera to come on,
You
but
don't have to. I can hear you just fine.
okay. They've been in Detroit for like 6 years or something. So, but I have the I have like Facebook stuff. I got pictures of her graduating. She she graduated in May of last year.
Hang on a second. All right. Well, this should be easy to figure out. Miss Dennis,
Yes.
do you
Yes.
do you know what we're talking about
Yeah.
here?
Let me just start off by saying this. Yes, it's going on 7 years that I've been here in Detroit. He haven't talked to my daughter since she was 12. She had life monumental moments, graduating prom. She in hair school. She graduate November of this year. So he never reached out to say congratulations, never, nothing on nothing. But it's temporary for him. It's a lifetime for me. She's 18 and she transitioning. She paid for cosmetology school out her pocket, trying to make ends meet. So that little bit do help. And as far as the child support goes, he ready to put an end to it because he don't talk to her. He don't talk to me. I done reached out, text him and everything, and it's nothing. But he could go down there to the court and say that she done and this and that. He got pictures when he don't even talk to her. My baby going through what she go through behind him. And I would like for the child support to continue on until her 19 to the end of her 19th year. It stopped in September. The court told me.
Now pay close attention to Miss Dennis. Her words echo with years of frustration and sacrifice. She recounts raising her daughter largely on her own, stretching resources, even lowering support at one point out of compassion, only to be left shouldering the full weight again. What makes her testimony so compelling is how she frames child support. To her, it isn't just about money. It's about acknowledgement of shared duty, a reminder that parenthood doesn't end when things get inconvenient. While the court focuses on timelines and statutes, she appeals to fairness, to the moral side of responsibility. Her statement, "It didn't stop for me, but it stopped for him," pierces through the legal arguments. It captures why child support hearings carry such deep emotional charge. Because at their core, they're about justice within families, not just numbers on a page.
In September of this year, but I would like it to go to her 19th year because I still have expenses with her. It don't stop for me, but it stopped for him. And he wrote that motion. She done with school. She done with that. He want to wash his hands of her completely. And I feel like that's so unfair that I didn't lay down by myself. I laid down with him. And not once he contribute to anything. And 3 years. I came down here and I lowered his child support to $35.
Yeah,
35.
right.
If you see in them records, you look in your records, see in the record, me and him came down to the courthouse. I lowered the child support down to $35 only on the strength of he get her on weekends, get her on holidays, get her on summer vacation. And he couldn't do that. And I had to wait 3 years to raise the child support back up because he still refused to participate. So
Okay. All right, I got the picture. I want to tell you both something. There's a lot of things I can do sitting here today. But there's two things I cannot do. And I hope the parties understand.
This is a turning point in the hearing. The judge pauses a legal sparring and delivers one of the most profound lines you'll ever hear in family court. Asterisk, I can't make somebody a good father or mother. Asterisk, it's blunt, but it's the truth. Courts have the power to enforce payments, set custody schedules, and issue orders, but they cannot legislate love, responsibility, or presence. That one sentence slices deeper than any statute. It's a reminder that parenting is far more than money. Real parenthood is built on emotional presence, consistent support, and showing up day after day. And when one parent falls short, no ruling, no paperwork, and no courtroom can ever fill that absence.
I can't make somebody a good father or mother. I can't do that. I wish I could. Because if I did, I would have probably very few of these cases. But I can't do that. And I wish I could, because I think your daughter deserves better. She deserves something. The second thing is I cannot violate the law. Okay? I have to follow the law. And the law in this case says that someone can collect child support until the child is 18 or graduates from high school, whichever occurs later. Now, she has done that, okay, by everybody's admission. So the law says that I have to terminate his child support, but I am doing it effective the date he motioned me, which is the first charge date. He motioned this on January 9. So the first charge date, somewhat close to that, is January 1. So I'm going to grant the motion to terminate child support effective January 1, 2020.
Here comes the unshakable reality of the law. The judge spells it out clearly. Child support lasts until a child either turns 18 or graduates from high school, whichever comes later. In this case, the daughter has reached both milestones, which means the legal obligation ends here. And this is where the disconnect becomes sharp. Ms. Dennis's heartfelt plea carries weight emotionally, but it cannot overturn statute. The judge's hands are tied, bound by the written law, not by sympathy. It's a stark reminder that in family court, no matter how powerful the story or how deep the struggle, outcomes hinge on statutes and evidence. The law may not always soothe emotions, but it sets the final word.
And what you need to do, Mr. Brown, is you need to come to the courthouse on the 5th floor Legal Assistance Center and prepare an order for me to sign, which you need to send to Ms. Dennis. And the order says that your child support obligation for this child terminated on January 1 of 2025. And I will sign that. And I wish everybody the best. I wish your daughter the best.
Say one thing.
Sir, yes, sir, can I say something too? I'll let her go first.
Stop.
Go ahead, ma'am.
Right. Go ahead, real quick.
Hey, so the courts told me that the child support is ordered all the way until September of this year. So you throwing that order out?
There's no order saying that.
That's what the courts told me. That I called it.
I should tell you this, Ms. Dennis, that unless you have paid the person to give you advice, you shouldn't rely on it. Okay? Mm-hmm. Because what I'm thinking is they may have told you What happens if she's still in high school? Maybe not. Child support goes until someone graduates from high school or turns 18, whichever is later. I've had a lot of 18-year-olds still getting child support because they haven't graduated high school yet. I've had a lot of 19-year-olds who get child support because they haven't graduated high school. But this child has graduated high school and is over 18, and the law says I have to stop it. But
This moment highlights just how quickly misinformation can spread in legal matters. Ms. Dennis insists she was told child support will continue until September, but the judge clarifies that advice from clerks or phone calls doesn't carry legal authority. Only signed court orders and official rulings hold weight. Everything else is just background noise. The judge isn't dismissing her frustration or struggle. Instead, he's reminding her, and everyone watching, that the law is exact and informal guidance can't override it. But here's the bigger question. Should the system offer more flexibility in situations where a child is still in transition, like moving into college or trade school? Or should courts stick firmly to the black and white boundaries of the statute?
date of a motion to stop it. This motion was filed January 9th. So the closest charge date I have is January 1. And that's as far as I can stop it. Like I said, all I can do is follow the law. And that's what I have to do. Now, Mr. Brown, what can I do for you?
Well, I got two questions. You said go over there to the 5th floor and get a what, man, sir?
Mr. Brown, you're getting yourself into more difficulties. You really need an attorney to help you because, so I need you to go, you know where the courthouse is?
Yes.
Here's an interesting twist. Mr. Brown technically wins this motion, but the judge still cautions with a firm reminder. Asterisk, you really need an attorney. Asterisk, the point is clear. Even when the law is on your side, the maze of legal paperwork and procedure can trip you up. The judge's advice is practical. Don't jeopardize a victory by mishandling the process. This moment also shines a light on how often people walk into courtrooms unprepared, underestimating the complexity of legal rules. It's a subtle yet powerful reminder. Winning in court isn't just about the ruling. It's also about managing the details. In legal battles, paperwork can be just as critical as the outcome itself.
It's called the Legal Assistance Center.
Right.
I need you to go there, and they will help you prepare an order terminating your child support effective January 1, 2025, and that all arrearages are preserved, period. That's all you got to do. And then they will prepare the order. You got to send a copy to Miss Dennis at her last known address. You send me the original. If nobody objects within 7 days, I'll sign it and you will be done and this case will be over. Okay?
All righty. Thank you.
You bet. Thank you. Good luck to you.
And there it is. The motion is granted. As of January 1st, 2025, child support officially comes to an end. The judge has followed the statute exactly, setting emotions aside and applying the law as written. For Miss Dennis, the decision feels like yet another chapter of abandonment. For Mr. Brown, it's the long-awaited legal closure he's been fighting for. But for their daughter, caught in the middle, it's a painful reminder. The law can settle financial obligations, but it cannot define love, connection, or parental responsibility. This case stands as a sharp lesson in how courts walk the tightrope between empathy and statute. And sometimes, the legal resolution leaves behind more of a scar than a sense of peace. If you found this case as surprising and thought-provoking as we did, don't forget to like, share your perspective in the comments, and subscribe for more courtroom breakdowns that uncover the stories behind the rulings.